Good evening and thanks for joining us for this month's monthly law update. Sorry we couldn't connect on Thursday and we had to move it to today. We don't have much on amendments or even the circulars and notifications aren't much. The Provident Fund organization has issued a circular with regard to the exempted trust and as to how the exempted trust should use their surplus and reserves for what purposes they can be used. A circular has been issued in this regard by the Provident Fund organization. The Provident Fund organization has also given certain guidelines for its officers on ensuring that the pension to pensioners are dispersed on a timely manner and how they should be giving details to the banks in this regard. Aadhaar seeding in ESI, again, how multi-employee data can be fed inside using the portal. Once more, the ESI Corporation has made certain guidelines, and they're also trying to reduce the delay in seeding and how the portal can be used by employers. A circular has been issued in this regard as well by the ESI Corporation. Moving to the next segment of our presentation, the quiz question for this month is an order of dismissal is issued without mentioning the reason for dismissal. Will not mentioning of reasons nullify the dismissal order? Please do put your answer in the chat box. In the across the globe segment, we are looking at a law where employees are allowed to go as volunteers for emergency situations like a flood or an earthquake or different kinds of natural calamities. And in such circumstances, there is a law in New Hampshire, US, where the employees can take off and the employer is required to sanction such leave. But because of this, there has been cases of where employees are being dismissed and there have been protections being given to such employees. In Belgium, there is a new requirement which mandates employers to register the training that they're providing to their employees in a portal. So it's to keep track as to whether employees are receiving their entitled training every year or at certain places, if it's even in a quarterly basis, that they are required to report it. In Sweden, there's parents are allowed to take paid leave during the child's first year of life. They now increased it to 60 days that they can be taken during the child's first 15 months. In this case, there was a demand by the trade union for a 20% bonus. The management contended, given their financial situation, position, they would need to pay only 8.33, the minimum bonus. The tribunal ordered bonus at the rate of 13%. This was challenged and the High Court upheld it on two grounds. One, it found that there was allocable surplus, and further, the balance sheet for 5 years had not been given by the management, and therefore the High Court confirmed the tribunal's award granting 13% bonus. A business executive was terminated just 2 months after his appointment. He was only on a probation. He challenged the termination, and the Tribunal Labor Court found that yes, though he was only a probation, there was no clear evidence that he was only on probation and granted him relief. But in the High Court, both the single judge and division bench held that he had worked only for 2 months. He was certainly on probation, and unsatisfactory performance is a good reason to terminate somebody during the probationary period. This month, in the Knowledge Corner, we are looking at the legal principle of loss of confidence. When does loss of confidence arises? It's a situation where the employer does not have trust over his employee. It could arise owing to the conduct of the employee, that is, the actions of an employee could lead to the employer losing trust, could be the behavior of an employee, it could be the performance. And loss of confidence, do we need to hold inquiry? But more than that, what is required is it should be a bona fide action on the part of the employer. The judgment on this regard by the employer should be bona fide. And also it should be supported by some evidence. The test that has been laid down, does the employee hold a position of trust and confidence? Whether the employee has abused the position, and would it be embarrassing and inconvenient for the employer to continue with such person in his services? So these are the three things that has to be seen when it comes to the question of loss of confidence. Loss of confidence being held to be a valid ground for dismissal by the Supreme Court, especially in cases where person involving sensitive company information like finance and the duty of the person involved. But there are also cases where even in respect of stenographers, or a typist, the courts have held that they hold a position of trust, and if they were to breach it, they can be dismissed on the grounds of loss of confidence. Is it possible for a court to interfere? Again, the Supreme Court has held that the Labour Court cannot, on it, just like that, substitute an employee's finding, or the loss of confidence is something that is to be assessed by the employer. The Labour Court should not exercise the discretion to alter the punishment in all cases, unless it is able to show that the ground of loss of confidence is not supported by any evidence. In this case, it was where an employee misbehaved with the air hostess. The Supreme Court once again found that the employer's bona fide loss of confidence was proved, and then concluded that the termination was justified. Will it amount to retrenchment? A termination on grounds of loss of confidence, will it amount to retrenchment? Courts have held no, that's not question of retrenchment. But the question arises because it is not a stigmatic order. So therefore, the question was whether it can amount to a retrenchment. And courts came to the conclusion that no, it does not amount to retrenchment under the Industrial Disputes Act. Is an inquiry a must? Again, there are two aspects to it. If an inquiry is possible, we would certainly suggest that you would need to hold an inquiry, but it is not a must, is what the Delhi High Court has held in this case that we have shown you. Can you say that you lost confidence because a person has deliberately refused to do the work that has been allotted to him? There are quite a few cases which was followed by the Delhi High Court, as you could see from the screen. And the Delhi High Court came to the conclusion that yes, a refusal to do work can also be considered as a loss of confidence. Of course, these are all subjective, and it would depend on the facts of each case. In this case, the Madras High Court found that the Labour Court's order granting compensation, despite the loss of confidence being held, the Labour Court went ahead to grant compensation, and the High Court found it to be a valid order, and they found that the Labour Court award did not suffer from any perversity. Moving on to our next segment, the Lex Posh that we are looking, the side judgment we are today looking is where a government employee, a colleague gave a complaint. Initial investigations were not very conclusive. However, a committee was formed, and the committee came to the conclusion that he was guilty and imposed certain punishments. The employee challenged the punishment, and the High Court found that there were procedural violations, like there was no cross-examination, there was no evidence, is what the High Court came to a conclusion. But the Supreme Court on appeal found that cross-examination in sexual harassment cases would not arise. You cannot set aside sexual harassment cases merely judged on basis of procedural irregularities. And also the High Court cannot function as an appellate authority and substitute its own findings. It's certainly not a case of no evidence. It's not a case of criminal case to look at a beyond reasonable doubt. And therefore, it concluded that the order imposing punishment by the disciplinary authority was valid. That brings us to the end of our monthly presentation. The answer for the quiz that we had posted is, at times, it is essential that the order of dismissal mentions the acts of misconduct for which an employee is being dismissed. But even if it is not mentioned, but if you're able to show that the employee was aware of the misconduct by referring to earlier communication that were issued to him before, like a charge sheet could have been issued or email could have been issued saying these are the reasons why we are unhappy with you and why we are going to proceed against you by way of a disciplinary action, then courts have held merely because the reasons have not been mentioned will not nullify the dismissal order. The complaints calendar for this month of November. We are moving our monthly updates to Mondays at 5 p.m. So we would connect again with you on 2nd December at 5 p.m. Please do join us. The PPT would also be shared to all our participants. Thanks for joining us.